While we await the verdict in the Delphi case, let's take a minute to have Ed Wallace weigh in on a key forensic question raised by the defense.
The jury also today heard from one of the defense witnesses who is an expert in ballistics technology. He says that when the bullet, the unspent bullet, was found at the crime scene, was taken to the Indiana State Police crime lab, and they couldn't get the results matching that bullet with Richard Allen's gun, so they changed the rules. They then, instead of injecting the bullet out of the gun, they fired the gun, which didn't happen that day by the creek, but in the lab they fired the gun. That's how they got the results matching the bullet to the gun. He says just by simply firing that gun, you're doing an apples to oranges comparison, and that's why the comparison, the defense hopes, that proves that Richard Allen's gun was at the crime scene is negated.
I disagree with the defense expert. It would be more accurate to say it's an apples to more detailed apple, comparing the ejector and extractor tool marks on a live cartridge cycled in an in and out of the chamber and then ejected from the suspect handgun to a cartridge that was cycled and ejected from this handgun after it was fired as being an apples to oranges comparison. It would be more accurate to say it's an apples to more detailed apple comparison. The state's ballistic tool mark expert was unable to replicate comparison quality tool marks similar to those found on the suspect cartridge by hand cycling live test cartridge. This is because she was missing at least two variables, if not more, and they are the speed and energy of the movement of the slide during the manual cycling of the suspect cartridge. In my opinion, she should have designed tests that allowed the suspect's firearms slide and live cartridges to be cycled and ejected by mechanical means whereby the speed and energy can be regulated, varied, and documented. You conduct these tests until you're able to leave similar tool marks on the test cartridges as those found on the suspect cartridges, and then you conduct your microscopic examinations, documentation, and comparison. At this point, you've identified and documented the possible aforementioned variables, and you should repeat these experiments utilizing the identified variables and confirm your comparison results. With all that said, it doesn't mean her comparison results are not accurate or true. Her work was peer-reviewed, and her comparison results were validated. The defense expert never looked at the suspect cartridge and the test-fired cartridges under the microscope. He also never tried to replicate her work with the suspect firearm, suspect cartridge, and the test-fired cartridges. He just looked at comparison photos and complained about her documentation methods. He also said the state's expert should have used a specific comparison technique that he prefers. Defense never once said her comparison conclusions were wrong. When asked why he didn't perform his own testing or microscopic comparisons, he stated he wasn't asked to by the defense attorneys. Well, I take issue with that. As a forensic subject matter expert, when discussing contracting work for a prosecutor or defense attorney, I explain to them what I can and cannot do. In addition, I tell them based on the facts what testing and examinations are normally done and what I prefer to do. And I make sure everything agreed upon is specifically detailed in my contract of service. There are only three possible findings of cartridge casing tool mark examination. Matching results, when the microscopic markings on a cartridge case from a crime scene closely match the markings on a test-fired cartridge case from a suspect firearm, it indicates a strong possibility that the crime scene cartridge was fired from that firearm. Non-matching results, if the markings on the cartridge case do not significantly match the markings from the test-fired cartridge, it indicates that the cartridge was likely fired from a different firearm. Sometimes the quality of the markings on the cartridge case may be poor due to damage, wear, or manufacturing variation, leading to an inconclusive result where a definitive match cannot be made. From what I hear from the reported testimony, no witnesses have testified that her conclusions were wrong.